Okay, let's talk about residence in Ireland from an immigration law perspective. Not everyone is entitled to live or reside in Ireland. Non-nationals are required to have permission to land or remain in the state. Some groups are exempt, however, from immigration requirements. 1. Those with diplomatic immunity. 2. Those with consular privileges. 3. UK citizens. 4. EU citizens. 5. EEA citizens. And 6. Refugees. 5 EEA citizens are those citizens from Norway, Iceland, Liechtenstein and Swiss nationals. The applicable law with regard to EU or EEA citizens and their family members, the law is set out in EU Citizenship Directive 2004/38/EC. This is known commonly as the 2004 Directive, and the European Community's Free Movement of Persons Regulations 2015. And in Ireland, this is Statutory Instrument 548 of 2015. With respect to UK citizens and family members, there is now, since Brexit, a change in the landscape and a scheme in relation to non-EEA family members of UK citizens intending to reside in Ireland. The Immigration Act 2004 is the main piece of legislation for entry and permission to reside in the state for non-EEA nationals. This Act sets out a list of non-exhaustive grounds on which entry may be refused by an immigration officer. Administrative schemes published by the Department of Justice set out the circumstances in which the Minister may grant permission to a non-national to reside in the state under the 2004 Act. The principal scheme is the policy document on non-EEA family reunification. Section 5, subsection 1 of the Immigration Act 2004 provides the requirement for a non-national to have permission to be in the state. It says that no non-national may be in the state other than in accordance with the terms of any permission given to him or her before the passing of this Act, or a permission given to him or her after such passing by or on behalf of the Minister. So a non-national who is in the state in contravention of this subsection 1 is for all purposes unlawfully present in the state. Section 9 of the Immigration Act 2014 sets out the obligation on non-nationals to register with their local immigration officer. The non-national, if successful, receives an endorsement on their passport confirming the conditions of their permission and the period for which it is valid. This is known as a GNIB card, an Irish residence permit. Registration in the Dublin area can be done for the first time registration at the Department of Justice Immigration Service Delivery Registration Office 1314 Burgh Quay, Dublin 2. Registration outside Dublin is usually done at a Garda station, and non-nationals must make an appointment to attend in person. Certain non-nationals will be allowed, or will not be allowed to register until they have made a formal application for residence permission to the Department of Justice Immigration Service Delivery. EU citizens and their family members are covered by the European Community's Free Movement of Persons Regulations 2015, that is Statutory Instrument 548 of 2015. Family members in this scenario can be divided into two categories, and these are EU citizens now, remember, and their family members. Qualifying family members and permitted family members. Qualifying family members and permitted family members are defined in the European Community's Free Movement of Persons Regulations 2015, that is Statutory Instrument 548 of 2015. For the purpose of these regulations, a person is a qualifying family member of a particular Union citizen where the person is the Union citizen's spouse or civil partner, a direct descendant of the Union citizen or of the Union citizen's spouse or civil partner, and is under the age of 21, or a dependent of the Union citizen or of his or her spouse or civil partner, or a dependent direct relative in the ascending line of the union citizen or of his or her spouse or civil partner. For the purposes of these regulations, a person is a permitted family member of a particular union citizen where the Minister has, in accordance with Regulation 5, decided that the person should be treated as a permitted family member of the union citizen for the purposes of these regulations, which decision has not been revoked pursuant to Regulation 27. These definitions have given rise to much case law around questions concerning dependency, household, durable relationship, as these terms are not defined in the 2015 regulations nor in the EU directive from 2004. The regulations provide that an applicant may remain in the state pending a decision on the application. So the non-national may reside in the state on a temporary permission pending the outcome of their residence application. EU citizens and their family members have a right to permanent residence in the state if they have resided here in compliance with the 2015 regulations for a continuous period of 5 years. Applications from family members of EU citizens who want to reside in the state are governed by the principles set out in the 2004 directive and 2015 regulations. The forms to be used include Form EU-TR1 for qualifying family members, Form EU-TR1A for permitted family members, Form EU-3 for an application for permanent residence, Form EU-4 for a review of any decision. And the Department of Justice page on EU treaty rights is an extremely useful page to check out, and it has extensive list of frequently asked questions about this topic. And there's a link on my website businessandlegal.ie to that Department of Justice page on EU treaty rights. UK nationals and family members. The Department of Justice has published a scheme concerning non-EEA family members of UK citizens seeking to reside in the state. A UK national may sponsor family members from Category 1 to Category 3 to reside with them in the state. This scheme has 3 broad categories of applicants. Category 1 is spouse, civil partner or de facto partner. Category 2 is dependent child of sponsor, of spouse, of civil partner or of de facto partner. Category 3 is elderly dependent parents of sponsor, of spouse, of civil partner or of de facto partner. This scheme sets out the criteria for both the sponsor and the applicant. These criteria include gross income requirements for the sponsor for the previous 3 years and police clearance certificate and private medical insurance for the applicants. Successful applicants under the scheme will initially receive permission for a 12-month period to reside in the state on stamp D4D conditions. Pre-clearance applications must be submitted from outside the state, and the applicant must stay outside the state when the application is being processed. And that particular scheme, the Department of Justice scheme published regarding non-EEA family members of UK citizens, you can get a link to that on my website businessandlegal.ie on the page dealing with residence in Ireland. Then we have non-EEA nationals remaining in the state. A non-EEA national or a third country national needs permission to reside in the state. Permissions are granted in different circumstances, such as the non-national having a valid employment permit, to study as an international student, or the non-national is the parent of an Irish citizen child or the spouse, civil partner or de facto partner of an Irish citizen. The irishimmigration.ie website is very useful. You'll get more information there. Permission is generally granted under the Immigration Act 2014, but there are administrative schemes which may allow the granting of permission to reside in the state. The Irish Immigration website has the latest information and schemes, and you can check out the policy document on non-EEA family reunification, which explains the permission to reside in the state based on family relationships. Hope you find this useful. If you do, I'd appreciate if you gave it a thumbs up on YouTube or give me a review on my podcast, the Irish Law and Small Business Podcast, and you can check out that article on my website, Residence in Ireland from an Immigration Law Perspective. My website is businessandlegal.ie. Just look for the category of immigration law and you'll find a good few articles and blog posts about immigration law in Ireland. Thanks a lot.